There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute.
All right, everyone. Today we're looking at another courtroom case involving someone using sovereign citizen style arguments. In this hearing, she's facing the court for violating the terms of her probation due to drug use. Instead of accepting a public defender, which most people in her situation would likely do, she chose to represent herself. As you can probably imagine, that decision doesn't seem to work out very well. Personally, I'm not convinced she's actually a sovereign citizen. It seems more like she's repeating arguments she's found elsewhere rather than speaking from genuine belief. Let me know what you think. Does she really believe what she's saying, or is she just following a script? If you enjoy this kind of courtroom commentary, don't forget to like and subscribe. Now, let's jump into the video.
And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one, you qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir, thank you.
All right, Ms. Clark, any opening statement?
Well, that pretty much ends any realistic chance she had of putting up a solid defense. I was expecting her to start using the usual sovereign citizen talking points. The claims that the court has no jurisdiction or that she's somehow exempt from the law. But surprisingly, she never went down that road. Honestly, that's probably for the best. One thing that really stood out was her decision to skip an opening statement. If you're representing yourself, that's one of the most important opportunities you have. It's your chance to explain your position, introduce your side of the story, and make a positive first impression on the judge. Passing on that opportunity, or handling it poorly, can make it seem like you don't have a clear defense at all. If you're going to represent yourself, you should at least use that moment to present your case. What do you think about how she's handled things so far? Let's get back to the hearing.
State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample from Miss Clark?
it was positive for methamphetamine.
So her
stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
that's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has
Is anyone else feeling a little conflicted watching this? On one hand, she's in court because of her own actions, so she's responsible for the situation she's in. On the other hand, seeing someone struggle and become embarrassed in such a public setting is difficult to watch. That sympathy only goes so far, though. She had access to legal representation and chose not to use it. The attorney was right there and appeared ready to help, but she decided to represent herself instead. That's the part one have the hardest time understanding. If you have a qualified lawyer available, especially one provided at no cost, it seems like the obvious choice. I don't really understand why some people who adopt sovereign citizen style arguments believe this approach will work. It almost always seems to make their situation worse rather than better. What do you think? Do you feel any sympathy for her? Or do you think she's simply facing the consequences of her own decisions?
Well, then,
Let's get
closing
back to the
argument, Mr.
hearing,
Marcinski.
because things are about to become
Your Honor, at
even
this
more
time, the state
serious.
believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument.
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right.
So now she's claiming she should be paid $1,200 for every minute she spends in jail. That's a remarkable argument. especially considering she's in court for violating probation after a case involving child endangerment and continued drug use. From that perspective, it's difficult to see how she believes she's entitled to compensation rather than facing the legal consequences of her actions. Earlier, I mentioned feeling some sympathy for her because representing yourself in court can be painful to watch. After hearing these arguments, though, that sympathy fades. When someone violates probation, they're taking the risk that the court will impose the sentence that was previously suspended. That's generally how the probation system works. Her comments toward the judge also didn't help her position. Whether or not they crossed a legal line, they came across as disrespectful, and speaking to the court that way is unlikely to improve the outcome of any case. One theme that often appears in sovereign citizen-style arguments is the belief that rejecting the court's authority somehow creates a legal right to demand payment or invalidate the proceedings. Courts have consistently rejected those claims. In this situation, the focus is on whether she violated the conditions of her probation, not on compensating her for serving a lawful sentence if the court determines a violation occurred. Now that we've reached the end of the hearing, I'd like to hear your thoughts. Do you think she had any realistic chance of avoiding the consequences of the probation violation, or was the outcome inevitable once the evidence was presented? And what do you make of the claim that she should receive $1,200 for every minute she's incarcerated? Share your opinion in the comments. If you enjoy courtroom commentary like this, don't forget to like and subscribe. Thanks for watching, and I'll see you in the next one.